Good morning to all of you. Today in the law of torts, our topic is no fault liability or liability without fault. Certain times we cannot fix up the liability on anybody, or we may ourselves be negligent and we may be liable also. In such cases, even though there is no fault, then still the company or still the insurance company normally, now it has come to liability rests with the government or the tribunal. So the compensation will be paid even there is no liability, that is no fault liability. Even though there is no fault, but still the insurance company or the government will pay you the money. That's for, please remember, only a fixed amount they will give. So this is envisaged under section 140 of the ME Act. Now I will read the section. Simple. Liability to pay compensation in certain cases on the principle of no fault. So if I want to give, so where the death or permanent disablement of any person has resulted from an accident out of the use of a motor vehicle, then the owners of the vehicle shall jointly and severally liable to pay compensation in respect of such death or combination. Here, please remember, no fault. I will simply give an example. A young boy was driving a motorcycle on the highway and incidentally, due to his rash or negligent driving, he hits the pedestrian, he hits the road divider and he gets injured. Here, who is responsible for the accident? He himself is liable for the accident. Even in such a case also, normally insurance company, what they will do, they will deny to pay insurance because he himself is negligent. How can you pay insurance? Then in such cases also, on the principles of no fault liability, the insurance companies, the hub of insurance companies, they will give the money. Of course, you have to file a complaint before the Lok Adalat. They will decide the issues. So please remember, this is a power given to the local authority. Why? Even though there is you are yourself fault, but since some damage has come, definitely under the principle of no fault liability. Here the question will not arrive as to who is liable, who is at fault. All these things will not be discussed. Simply, accident has come, accident has occurred, some damage has taken place, some death has taken place. Therefore, you will be paid the compensation. So it is fixed according to 150. If any death occurs, so 50,000. If any physical or the so-called injury or grievous injury or some whatever it is, physical disablement occurs, so 25,000 will be given. Of course, this is latest amendment act. So there is another topic called as hit and run cases. We will discuss later. Now, as far as section 140 is concerned, please remember, even though there is no fault, then you are liable to pay, the insurance company is liable to pay fixed amount, but there will be no appeal on this also. In case of state of Assam versus Parnesh Devabrat, 1993, please remember, so principles of no fault liability, it is once decided by the Lok Adalat, no appeal. So in the case of no national, the so-called no fault liability, no appeal, but it can be treated as a revision. So once again, you can approach the court. So just like our review, you can ask it for revision, but not more than that. Now we'll discuss a couple of case laws. Oriental Insurance Company Limited versus Lal Kaur and others. Lal Kaur, she is the wife of that constable. So he is Surinder Pal Singh. Surinder Pal Singh was working as a constable in Delhi, right? He was aged about 36 years. On the particular day, 21/5/99, he was going on a motorcycle belonging to his friend. It is not his own motorcycle. And the vehicle met with an accident with a Tata Sumo, UP 164048, something. So he died. Of course, first he received injuries, he was hospitalized, there he died. So his wife, Surinder Pal Singh's wife, Lal Kaur, actually she filed a case under section 140 in the first instance. Later, after coming to know about the vehicle and other things, then they have gone for 166 of the ME Act also, right? But here the point is, the tribunal came to the conclusion that the accident occurred due to the rash or negligent driving of the sumo driver. So therefore 5.7 lakhs was amount. Please remember here actually she was thinking that her son was at fault, her husband was at fault, motorcycle driver was at fault, but the tribunal declared that the Tata Sumo driver was at fault, therefore 5.7 lakhs was awarded. Another case, New India Assurance Company Limited versus Raghu, 1996. So here what happened is, Raghu's daughter, she was working as a laborer. She was on one day, she was going in a tractor trolley. She was sitting on the trolley. Actually, she paid money for going in the trolley also, right? So en route some accident took place and she died. Here the owner did not agree that the money was paid by that minor girl. So even though so it is a trolley, since it is of course since it is insured, the insurance company says they need not file and they need not pay anything because trolley is not supposed to carry any passengers. But here the claims tribunal held that even though there is no fault on that party of the party, then since death has occurred, they have to pay the so-called 50,000. Yes, ordered. No fault, basing on the principle of no fault. Here, the tribunal did not want whether the driver of the tractor is negligent or not, but some incident has taken place, the vehicle turned red till, therefore they have to pay the money. So, these are simply the cases relating to no fault liability. I hope you understood. No fault liability, please remember, whoever may be at fault, the insurance company will pay. But only thing is, you should not go for 166 in the later stage. 166 already. So it is a claim petition before the. So normally these cases will occur in self-accident cases. Normally these instances will be self-incident instances or where there is no insurance. Second point. So this is another point. Right. Please learn this much and it will be helpful to you. Thank you.